Hi, this is attorney Greg Dell here with attorney Cesar Gavidia, and we're going to talk about Metlife long-term disability lawsuits. This is a company that we've sued hundreds of times all over the country. They're one of the top 5 largest group disability, long-term disability insurance companies. And the person who's watching this video, we're making the assumption that you recently had your appeals denied, meaning you've already filed an appeal, it's been denied, and now you received a letter that you have the right under ERISA to bring a lawsuit. Obviously, if you don't have ERISA and you have a private individual policy, which we've handled tons of those as well, you go right to court, possibly without doing an appeal, and you file a lawsuit. But we're going to focus here on ERISA and the requirements that come with that, and get into the expectations as to how the process works. We're going to talk about the possible incomes. Then we're going to share our views about how aggressive or non-aggressive Metlife can be in fighting these lawsuits across the country from our experience of handling so many of these. So first thing I want to talk about is, what are the steps now that this person's sitting there with this letter that says you lost your appeal, sue us?
Right. So now you know most people aren't going to go and file their own federal court lawsuit.
Right.
Okay. So this is when 99.9% of claimants who've been denied by Metlife are going to reach out to a lawyer. Okay. And that lawyer is going to, we're going to obtain that administrative claim file. Okay. The last claim file having everything that basically Metlife is considered from the time they filed their claim up to the final decision on that appeal. And then we're going to begin constructing that federal complaint. It's a federal pleading. It goes through basically from start to finish everything that was done in that claim, Metlife's conduct, what Metlife did wrong, how they violated ERISA, how they violated the terms of this policy, and what you're owed, what damages you're owed, from their failure to pay your benefits. So once that's filed, we're talking about 30 to 40 days before Metlife gets their lawyers and respond to this, okay? And most of the time, they're going to seek an extension, which is never denied by the federal court judge. They're going to be served probably within some time frame of, a week or 2 weeks, but by the time it gets up to New York and it gets in the in-house counsel's hands, then it gets delved out to their outside counsel.
Right.
to respond to our complaint. We're talking about 30 to 40 days possibly. And then that's when the litigation begins. We're not talking about, because of ERISA. One of the things about ERISA, it is streamlined. We're not going to have extensive discovery or anything like that. It is going to be a streamlined process where, depending on the court's timeline, could take up to 12, possibly 16 months before there's any sort of official resolution to it if the case ends up in the judge's hands to adjudicate or, to have a bench trial on.
Right. The nice thing about the federal court with these lawsuits is that the judge is going to issue what's called a scheduling order. And in there, the judge is going to set a deadline. And sometimes I've seen it as quick as 6 months to say, you got to have summary judgment motions done within a 6-month period.
So some of these judges are now kind of catching on to the ERISA system. Now, some could say that's good. 6 months, well, I'm not going to have to struggle that long before a decision's made. But there's a lot that goes on in that time frame. And even having, sometimes there could be some drawbacks to having a very short time frame, or what they call a rocket docket. Okay, because it blasts you right off, and you're right in kind of your final judgment phase, within 6 months. But when you think about how long it takes for, them to respond, them to answer, and for things kind of unravel, and for them to start understanding their exposure and liability in the case, and for their lawyers to, that time frame really creeps up on you.
Okay, a lot of people, thinking about this are they watch lawsuits on TV. Everyone, for people our age, OJ on TV, and now every single TV, show with these trials
Court
go
TV
on.
and everything.
These trials go on forever. But one unique thing about ERISA, which is somewhat of a convenience factor for a claimant, is that our client is not going to have to do anything once we file this lawsuit.
Right.
Basically,
they technically don't even have to appear in federal court.
Right. Well, they're never going to give you your day to appear in court. Your lawyer does everything. You're never going to be deposed. You're never going to be asked to fill out interrogatories. You're never going to be asked to produce documents. We're never going to depose your family members, your employer, your doctors, anyone else around you. None of the stuff you see with these depositions going on are going to happen. The only possible depositions are going to be us taking depositions of Metlife employees, Metlife claims handler, And that isn't even a given. That's something that has to be granted. So from a convenience factor, that's a plus for you, because you can basically, once you hire us, there's literally nothing for you to do as the claimant. So that's one advantage. Disadvantage in the sense that we would love to be able to take depositions and love to have you come to court and tell your side of the story and have your doctors come in and explain what's going on with you. ERISA doesn't allow it. We're married to the administrative record, which is what you said, every single document that was from the inception of the claim until Metlife said, we're not paying you.
Right.
Done,
and this is your final
story.
appeal, right? This is it.
So we work off of that, and these cases resolve in what's called a summary judgment motion. Explain how intense and how detailed and how extensive those motions are.
Summary judgment motions, I mean, when it comes to one piece of paper being the final adjudication of this matter, it's obviously going to be extremely important. It's a federal court pleading, all right, that basically there's no genuine issues of material fact left. You basically have to, put down every argument you have in terms of how MetLife violated ERISA, may have acted arbitrary and capricious, put in all the case law, and you have to be up to date on every single case, because ERISA cases, they're constantly in flux, they're constantly changing. So you have to be familiar with that last case that may have been involved MetLife, may have involved another company, but it's very analogous to your facts in your case. And of course, they're going to respond. Right? They're going to file a response in opposition to your summary judgment, and they're going to file their own summary judgment motion, and then you're going to be responding in opposition to their summary judgment motion. And sometimes you can get cross motions, and it gets very convoluted in terms of, what is what and when you have to file what, but we usually have it all down to a science.
So when it's all said and done, when you have a claim file that's usually on average a minimum of 1,000 pages, especially after an appeal, you have all the case law from all over the country. You're talking about hundreds of hours of legal work to get to an end result. I know one of our cases, I submitted well over 1,000 hours of billable time to get to a final solution. So these hours add up tremendously, and they're very complex in the appeal. When you file a lawsuit, some companies, they roll over, some fight aggressively. Where's MetLife on the spectrum of how hard they're going to fight a lawsuit?
I could tell you that MetLife is one of the most challenging disability insurers to battle against, because they don't usually ever give an inch in terms of admitting any sort of wrongdoing or liability. I've had other disability insurers who've looked at a set of facts and they said, we did make a critical error here. We want to reach a resolution with your client. Here's a very reasonable settlement, or we're going to pay them what they're owed, and we want to remand back to the insurance company so we could consider ongoing benefits. They're basically admitting liability and that they were wrong. I have yet to see MetLife do something like that. They usually stand very confidently behind their claims people and behind their decision. That's not to say we haven't resolved all our cases with MetLife. I think, there has been, we are very, very good at showing their exposure. They may not reveal it to us, but I'm sure that behind closed doors, they're talking about their liability and they're talking about their exposure that we've argued to them and that we're basically, exposing them to.
So let's talk about the reality of how your MetLife claim is basically going to play out. So when we evaluate thousands of cases every year, and we only accept a certain number of cases every year to take on, and especially with MetLife. So if we take your case, we think we're going to recover benefits for you. Now, does that think we are telling you right now that you're going to go to verdict? No, what we're saying is that we think at some point in time on your case, if we accept it, that you are going to get some kind of financial offer for your claim. And that's going to come in the form of a lump sum one-time fee settlement. And when you get that offer, and I'll just use an example, say your claim, all your benefits are worth $250,000. At some point, you may get an offer for $50,000, $75,000, $125,000, whatever that number is. Once you get that number on the table, it becomes a pure financial business decision for you. Because if the most you can get is $250,000 and you've been offered $100,000, you now need to decide, are you going to invest $100,000 in this particular case with this judge, with whatever the risk versus the rewards are, to try to get $250,000? And the reality is that 96% of the claimants who get an offer are not willing to take the risk to go to trial to try to get 2 or 2.5 times the money they got, because 80% of these cases are won by the defense. And
Right.
that's because of the case law, not because of poor lawyering, just because the case law is that the judge is forced to defer to the insurance company. And we've talked about that in our arbitrary and capricious ERISA videos, which we're not going to get into right here. But certainly when you call us to discuss your claim, we'll get into strengths and weaknesses of your claim individual. But you should know on a positive side that no matter how hard this is, there's going to be an offer of money for you, and it's going to come down to your decision, not ours. We're just going to tell you the risk. We want to pound MetLife. We want to get the verdict for you. But we also want to see you walk away with as much money, as possible for this MetLife claim. So time is of the essence. Obviously, if you have this denial, you should contact someone right away. There's a statute of limitations that has to be complied with. If you don't file your lawsuit timely, you could be forever barred. We've seen that happen before, and that's horrible. So the process is either click to submit a free consultation on our website. Just pick up the phone and give us a call right away. One of our lawyers will answer your call. We'll ask you to send us a copy of your denial letter. We'll review it immediately. We'll let you know in a matter of minutes if we think that you have a claim that we could help you with. We help claimants all over the country, no matter where you live. And most importantly is that we're not going to charge you any fees or costs unless we make a recovery for you. So there's no risk whatsoever, and we want to do whatever we can to get you the best possible outcome. We thank you for considering our law firm.